Strap in because this courtroom isn't pulling punches. What starts as a routine hearing spirals into a storm of allegations, trauma, and one of the most emotionally charged confrontations you'll ever see. We've got a defendant claiming discrimination, a judge citing felony after felony, and a hit and run with a side of fast food. The question at the center of it all, is this about justice or judgment? With a prior record that includes assaulting a peace officer and injuring a child, plus new charges of evading arrest and failure to stop and give information. The courtroom tension here is real, and just wait, because in this case, the gavel isn't the loudest thing. The truth, the emotion, and the backlash, that's what's going to hit hardest. Let's dive in.
Dispatch to 15357 Wallaceville Road in Harris County, Texas, regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time.
Let's pause right there, because that moment is crucial. The defendant not only allegedly fled the scene, but reversed her car and struck the complainant a second time. In legal terms, that changes everything. We're now talking about intent, not just negligence, and the excuse, "I was hungry and colored." That statement and the act that followed raises the stakes dramatically. Is this a hit-and-run turned aggressive assault, or a misunderstanding wrapped in frustration? You tell us. If someone hit your car, refused to give info, then reversed into you, what would you call that? Drop your answer in the comments. We want to hear your take.
To see if she has a valid Texas driver license.
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege.
This is where the hammer drops. The judge just took away her privilege to drive. And for anyone unfamiliar, yes, it is a privilege, not a right. Especially when you're on felony probation. Let's also unpack that background. Assaulting a peace officer, injuring a child, evading arrest, and now this? That's a legal rap sheet with serious weight. But then she says, wait for it, I'm a commercial driver. That's a jaw-dropper. Because if true, the standards for ACDL are even higher, and her driving record could now end her livelihood. What do you think? Should she ever get behind the wheel again?
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
This case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally.
At this point, the court's not just dealing with evidence, it's juggling emotion, trauma, and public safety. The judge acknowledges the allegation that the second hit might have been intentional, and that opens the door to more serious criminal charges, possibly assault with a vehicle. Meanwhile, the defendant is unraveling emotionally, and you can feel the courtroom tension climbing. But here's where it gets tough. How do you balance compassion for someone's mental health struggles with the responsibility to protect the public from dangerous behavior? There are no easy answers, but the judge makes it clear this is about consequences, not character.
May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. She has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition.
Here we see the public defender step in with a strategic pivot: mental health. And it's a common defense tactic in complex cases. Humanize the defendant, explain the behavior, and demonstrate community ties. She's a single mother, long time resident, and unmedicated during her past offenses. The lawyer even requests mental health court. It's a strong move, but the judge isn't just considering background. He's watching demeanor, prior record, and the pattern of behavior. So ask yourself, do mental health struggles excuse repeat endangerment? Or does that make the system's response even more important?
I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
Don't say anything.
how many people died this weekend on the road because of the reckless and wanton actions? You know, all we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
Don't say
me.
anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own,
You
right?
don't understand. I'm colored. You don't understand.
And now, the case explodes into something much deeper. Ace, you don't understand me. I'm colored. The defendant says it's a powerful, painful moment, one that demands reflection. The judge's response, that justice is colorblind. He claims he calls out discrimination no matter what. But here's the thing, courtroom justice doesn't exist in a vacuum. Real people bring real trauma into that room, whether from their past, the system, or society. The hard question is this: can someone still be held accountable, even if the system has failed them before? Or is that failure reason enough for leniency now? We want your thoughts below.
I mean, what happens in the case? And from what I see here and what has transpired here within the last 10 minutes, really?
Officer Harris did not read me my rights.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind her the officer car, I did not get a voice to speak out anything.
Yes.
It just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave
And just like that, after the shouting, the charges, the tears, the judge shows restraint. He leaves the bond at $1,000, but the warning, crystal clear: do not drive. Do not pick up a new case. This hearing showed us a lot: the weight of repeated violations, the impact of unaddressed trauma, and the complicated intersection of race, law, and mental health. So where do we draw the line between redemption and recklessness? If you found this case as intense and thought-provoking as we did, hit that like button. Drop your opinion in the comments. And subscribe for more real courtroom breakdowns that cut through the noise. Justice isn't always black and white, but will help you see the whole picture.